Can you hear me? Good morning. Welcome to this second day of our conference, and welcome to our panel. We will discuss representative and collective actions across Europe. We have here a great panel mixing different backgrounds from finance to economic, legal, and different jurisdictions, including UK and other, and then continental European jurisdictions such as Portuguese, which is my case, the Netherlands, Germany, Spain. And I would start by asking the panel to introduce yourselves. You want to start, Charles?
Sure, with pleasure. Good morning, everyone. So I'm Charles. I'm with Deminor, and I've been with Deminor for over 24 years. I'm the current CIO, so Chief Investment Officer. I'm also a director at the European Litigation Funders Association. So as you can understand, Deminor is a litigation funder. We have developed our business mainly in a context where class actions were not a reality, were not available. So we really developed an opt-in practice, working primarily on investor claims, so securities litigation, and then competition law. And since a few years, we are what you would call a mainstream litigation funder, meaning we also fund one-to-one, so individual claims like arbitration or other types of commercial disputes.
I'm Peter Davis. I'm with the Brattle Group. My background is originally as an academic. I taught at the Sloan School at MIT and then at LSE. Spent some time in private practice, and then as an academic when I came back to the UK. I then went to the Competition Commission, as it was then, now part of the CMA, and served on their board. And it chaired a number of investigations. But most recently, private practice has been my role, and in the class action space, in particular, I'm serving as the expert in a number of the applications, and both in process and succeeded in front of the Competition Appeals Tribunal. I suppose the one that's been going the longest is the Road Haulage Association's trucks case, but it's serving on both defense and claimant sides.
Tamrat.
Morning all. Hi, I'm Tamrat Shone. I'm a competition economist at Oxera, where I've been for around 10 years. And I work across the full range of competition products, but have a particular focus on competition litigation, so assisting Oxera experts in the preparation of their evidence for courts. And I also focus particularly on the UK, but also more broadly. So that's where I'll be coming from mostly in this discussion.
So, and I can introduce myself. My name is Joana Neves. I'm a Portuguese lawyer. I work with VDA, which is a full-service Portuguese law firm. We have a Seeker 50-lawyer dispute resolution practice. My practice has been focused on commercial and civil litigation, and also arbitration. And in the past years, we focused also in collective actions in Portugal, and also disputes related to technology and consumer protection. So we have a great panel here with this mixture that I hope will foster a dynamic and provoking debate. And without further ado, I would now move on to our first topic, and which relates to the current trends in European jurisdictions continental and also in the UK. It is true that the directive has not been transposed in many member states, and it's not applicable to the UK, but still we have seen in the past years some relevant developments in various jurisdictions across Europe. And I would like to ask the panel your views, what you have seen in the jurisdictions where you practice. Do you want to start, Charles?
Sure, pleasure. Okay, I'll have to stay at very high level because we are funding litigation in several European countries. You could say a lot about each and every one of them. I will start with the Netherlands. I know most people think the Netherlands are the hub for collective actions in Europe. We have a more nuanced view. We have been funding and we're still funding collective actions in the Netherlands. I think there are many advantages there, but we haven't really seen a significant growth of collective actions. I mean, every year we conduct a review of collective actions filed in the Netherlands. And what we see is, since 2020, which was the first year of the, what they call the WAMCA law, there's not been a constant increase of cases. There is also, and among the cases that have been filed only, if we take the first 3 years until 2022, only 1/3 of these claims were funded. So when people say funding is going just to trigger a tsunami of collective actions, I think it's greatly exaggerated, at least in the Netherlands. What we also see is the Dutch courts are not opening let's say, the gates of the courtroom very widely. We've had a few decisions recently. I think the Airbus case, 2 claims brought by foundations, dismissed by the court, finding that they were not either representative or not, to use a word they often use in the US, adequately representing the class. Not enough independence from the funder or from the founder of the stichting, so the foundation that is bringing the claim on behalf of the class. And I think last Friday, a decision in the TikTok, it's a privacy claim, a decision of the court in the TikTok case was issued. It was, I think, issued earlier on, but it only became public last week. And then the claim was partly dismissed regarding non-material damage. And also the court, there were 3 competing claims, and for 2 of them that were backed by a funder, a commercial party as a funder, the court said, if you want to move on, you need to revisit the funding agreement because I'm not satisfied with what I read in the funding agreement. So you see, it's a kind of nuance. I personally think it's good to have the courts sending out a message. You need to meet certain criteria. I think it's part of the maturing of this system in the Netherlands, but it's not necessarily negative. Germany, as you probably know, Germany, they have a new law, was adopted by the Bundestag and now by the Bundesrat, was published around a month ago. There, we are deeply concerned about the choice made. I think they really restricted the ability for class actions to be brought in an efficient way because they put lots of constraints on the funding. So I don't know whether you've seen this, but funders could not get more than 10%. So there's a cap. It's really a cap. You can't get more than 10% of what is awarded to the class. Italy, we have funded also cases in Italy, but rather bundling claims. Class actions, we have not seen that many class actions in Italy. It's a bit like in Spain. In Italy, they have implemented the directive. In Spain, they're working on it. In Spain, there is a boom in collective actions and group actions, but it's kind of weird because on the truck case, and I guess several of you are familiar with the truck case, while people are trying to bring collective cases, so bundled claims in Europe. In Spain, it's individual claims. And I think we are now over 2,700 appeal decisions in Spain only on the truck case. So there's still, I think, an education to be made there in Spain. France is a huge question mark for me personally. It's one of the largest economies in Europe, but I've not really seen a great appetite for class actions in France. And then you have at the European level the big discussion about whether or not you should regulate funding. It's an initiative from the European Parliament. Maybe it's related to the Collective Redress Directive that was not really addressing the topic of funding. So what we see, the trend is, I don't say I'm going to be optimistic. I think the conclusion would be, it will require much more work upstream in order to bring successful collective actions in Europe. So it's not going to be easier, but maybe that's going to be the best test for the would-be candidates to bring collective actions in Europe. You need to pass the test.
Thank you. Peter, I know you have some numbers and insights on the UK.
Well, I do. I'm going to focus mainly on the UK because that's the jurisdiction I mainly work on. I will say that we are seeing requests for preliminary damages estimates that go to other jurisdictions as well, including Portugal, the Netherlands, and of course, lots going on in North America, both Canada and in the US. But let me focus on what's happening in the UK. Let's see if I can provide some slides. So this is just showing you the growth. Since, if you remember back in the day, way back in 2016, there was mobility scooters. And we had the early days of merit, I guess. And you'll see over time from that first column there, 2016, where there are 2 cases being launched, the growth, so that in 2022, 9 cases are registered on the CAT website. And I should say, compared to a previous version of this graph that I put together a few years ago, these are 9 cases counting the similar cases as one. So if you have the same class rep, and even if you've got different defendants, then that's counted in this graph as the same case. Now, 2023, you'll see that we've got 6 applications that are registered on the CAT website so far. These are figures up to September 2023, and there's always a delay between the actual registration of the case and it showing up on the CAT website, so that's an underestimate. The other big change I think we've seen in the last couple of years is to more of a balanced portfolio. So if you go back to 2021, it was 6 standalone abuse of dominance cases and only one Chapter 1 case. But now we're seeing a mix of abuse and agreements cases going into the CAT, both standalone and follow-on. There's a range of sectors, and this is just showing you the number of cases broken down by the sector the case is in, and you'll notice that there is a lot in information and communication, 9 cases since 2021. I guess no surprise there, lots of tech cases. But that's by no means the only sector involved. We've got, for example, a fair number in transport. One of the key trends we're seeing is the speeding up of the process. So what these graphs do is take the cohort of class actions that are being launched in a given year, and then count the number of years from the registration of the claim to the first CPO hearing, and the number of months from the CPO hearing to the CPO judgment. And you'll see that the process is speeding up. The height of those bars, the number of months or years taken to that next hurdle is coming down with the cohorts. And so that's a very significant change. Excuse me. The other trend, just to point to, is that the funders that are at play are a really diversified group. So there are 6 different funders between the 6 cases registered in 2023. For 3 of them, it's their first case. Okay, what we're not seeing is a given funder coming in and funding lots and lots of cases. We're seeing, since 2016, 7 funders have only funded 1 case in the CAT so far. Another 7 have funded 2, and then so far there's only 1 which has funded more than 1. I should say the data there is a little bit incomplete. So that's our best understanding as it stands at the moment. So those are some of the trends we're seeing. It's a positive picture, the growth in this area. And I think it's worth underlining, particularly in light of Jessica's remarks as the keynote speaker, that this really represents a tremendous expansion of enforcement. Mm-hmm. And there can be different views on that, whether that's a good thing or a bad thing. But certainly, if you look at the scale of the budgets in these cases, where the largest cases are having funding budgets of tens of millions of pounds, that is a really significant change compared to the CMA's budget, I guess, is around 100 million a year for doing everything from merger control to state aid to the DMA and as well as enforcement of Chapter 1 and Chapter 2. And so that movement towards the growth in the class actions, the growth in private litigation here is a really significant change.
Yes, Peter, it's interesting. I was focused particularly in speeding up of the proceedings. What do you think has been contributing to that?
So the big piece, I think, is the removal of some of the uncertainty. So the early cases went through a process where there were lots of appeals, and Merrick's in particular, the Merrick's v. MasterCard case, went up to the Supreme Court, and a lot of cases were put on hold, essentially, while that process happened. Now the regime at the CPO stage seems to me to have clearer, but still evolving in some respects, we'll go on and talk about, no doubt, a clearer set of guidelines, and so that process is happening more speedily, is my impression. But others in the room or on this panel may have
yes, thank you, sense. Peter. Tamrat, as a competition economist, what have you been seeing in the UK or other jurisdictions that you cover?
Thanks. Yeah, so I think we've been seeing novel class claims in both the UK and also EU regimes, such as the Netherlands. And in both cases, the role of economics remains important. So in the UK, class claims need to stem from a breach or alleged breach of competition law. Now, the setup of that regime means that claims that might more naturally be framed as, for example, an infringement of privacy or consumer protection law have been brought as standalone competition claims. And the idea is that basically, if successful, they could benefit from the advantages of an opt-out regime without potentially facing the same obstacles, such as the same interest test that they would face if brought as a representative action under CPR 19.6 in the High Court. So an example of this is the today unsuccessful Gormson versus Meta claim, which we discussed yesterday, which is a data protection case framed as an allegation of an abuse of dominance. And basically, in these standalone cases, economic experts take on added importance, because in a standalone case, you have issues like market definition, which need to be dealt with, particularly where cases are being brought against digital platforms who connect two sides. Market definition raises complex issues. In addition to market definition, you have issues like dominance, liability, and causation that economic experts need to grapple with. So there's multiple added layers. So on the European side of things, some of the EU representative regimes have gone beyond the directive's minimum requirement of sanctioning violations against EU consumer protection law. So for example, the Dutch WAMCA regime covers all areas of civil law. And what that means is that's enabled quite novel claims to proceed in their own right, particularly under the Dutch regime. So you have, claims against KLM for greenwashing, the claim against TikTok, which Charles mentioned, for collection of data. And I think, in these cases, economists also play an important role because, we need to think about the counterfactual. In an antitrust case, we might be asking what is the price absent a cartel or an abuse. In a greenwashing case, we would be asking, what is the price absent the sort of alleged environmental benefit? So we have the tools to deal with those issues. And the way we might go about that in, for example, a greenwashing case is, there are hedonic pricing analyses which effectively take a product and decompose it into its constituent parts and value what each, it sort of estimates the value of each of those parts to the consumer. So you decompose a product and you say the green part of the product, the environmental parts, such as, a reduction in CO2, how much does a consumer value that? Another way to do that is through surveys. But effectively, the point is that there are novel claims both in the EU and on the continent, and economics still has an important role to play.
Thank you, Tamrat. And also addressing the Portuguese jurisdiction, I can give some insights. What we have seen is that although we have a long-standing and well-established and broad class actions framework, in recent years, and this framework, it comes from the 1990s, so it has more than 30 years. But still, in recent years, what we have seen in Portugal is an increase of class actions, not only in terms of number, but mostly in terms of value and sophistication. So just to give you a simple framework, our class actions regime, it's foreseen in the constitution, in the Portuguese constitution, the right to sue a popular action, which is the name that it's how we call it. There's this law of popular action that's coming from the early 90s. And the main features include, well, it's an opt-out system, irrespective of the subject matter that is at stake. And it is foreseen for for the protection of different interests, including consumer, public health, environmental, cultural heritage, and so on. And it has a broad legal standing, meaning that not only associations and foundations are granted legal standing, but also individuals, Portuguese citizens. And then there's also a broad scope of remedies included. It includes interim measures and, of course, compensation. And these features have been established and discussed in the court practice, and they will remain despite the transposition of the directive. But despite that, what we have seen is that the directive has not been the great driver for the market. what we have seen is that new and more sophisticated claimants are coming in, associations, and with international network, international access to information, and this has led to claims being brought in Portugal, and that are similar to claims that are brought in other jurisdictions, such as in the UK and in the Netherlands. We have also seen a greater, this is a feature that was mentioned yesterday, greater awareness from civil society and also the legal market, and then the coming in of funders. And this has led to important developments in the past 5 years, with a lot of new lawsuits being brought in different issues, covering different issues like data protection, competition as well, consumer protection, and this has happened despite the transposition of the directive, which has not been concluded yet. And now that, I don't know if you know that our Prime Minister just dismissed, so will resign, so we will see how this transposition, how long it will take, but we hope it will take a few weeks, I think. So moving on to our next topic, and what we have seen from the panel's insights is that a lot of difference still remain in the different jurisdictions, and this poses important challenges to assessing the economics of a claim of the cases, and assessing the risks and benefits, damages. So I would start, Peter, do you want to give your views on this, how the different jurisdictions impact the way you assess the economics of the case?
Well, as I say, mainly I work in the UK, so, but I can give you some impressions, and just to illustrate the scale, potentially, of the differences. If you think about a topic like disclosure, important to all of us. As economists, we can't do our work unless we get some information, which sometimes is available in the public domain. In cases around financial services, for example, there's often data in the public domain. In other cases, we can sometimes find some information. But you know, ultimately, there's going to be a lot that you'd expect to come from disclosure. And so the disclosure regime in a given country is going to affect the way the economics is done and when the economics is done very substantially. And the clearest distinction, of course, is between a US class action and a UK one, which are polar opposites in that in the UK we don't see disclosure usually, although there has been one case in the Apple battery case. I understand there has been some disclosure at the certification stage, but in all the others there hasn't been pre-certification. And so what we're really tasked with in the UK is developing sometimes called a blueprint or a roadmap. I like to think of it as a project plan. So as the economists, you're tasked with essentially understanding what the theory of harm is, that the claimant, the class representative is the basis of the claim, translating that into economics, and then trying to get to the key steps that would need to be shown in order to establish that claim or evaluate that claim, and then put that in practical terms. Okay, what are you actually going to do evaluate market definition in this case, in an abuse case, to think about dominance, to think about how to evaluate the abuse of dominance, or if it's a follow-on where the focus is on causality and quantum, then what you're going to do to quantify the damages, what it is, what's the benchmark you're going to use for what competitive prices would have been, or competitive quality levels would have been in the counterfactual. So the UK is a project plan, and we have really significant debates about that project plan. So in the Road Haulage Association case, I think I filed 400 pages or thereabouts of expert reports on methodology. That's a follow-on case where the focus is quantifying damages. And I think there were, I forget whether it was 8 or 10 defense expert reports filed in that case as part of the certification process. So we're seeing very significant, in some cases, we're seeing very significant debates around that project plan and whether or not it meets the UK test for being a credible and plausible approach, and the evidence that some of the data are available, and the other parts of the process test that's been adopted in the UK. Now, of course, in the US, you're seeing all the disclosure happen right at the beginning, lots of disclosure happening right at the beginning, and so the exercise is fundamentally different. I did a bit of work on one last year where, we were, the team were putting together, a data set with hundreds of millions of observations from 12 different defendants, and it was really a matter of marshalling heavy-duty data sets into some kind of coherent whole, when of course companies' data sets use different definitions. To do that, you've really got to understand what's important in pricing. Right? You can't, you've got to understand the heterogeneity in the products, you've got to understand the heterogeneity in the customer bases, because what you want to do at the end of the day is develop a methodology which is a common one, or evaluate whether there is a common methodology that can be applied at the trial of the common issues. So those are two very different approaches we're seeing at Class Cert. In the European jurisdictions, when I talk to my colleagues, they are full of stories of very limited disclosure and the difficulties that raises. Colleagues in France talk about trying to explain that actually, economists need data. I think colleagues in Germany explain the challenges of having a court-appointed expert, and that you might be surprised which side of the case might want to encourage disclosure, and still not always having backing from the courts to disclose information. So I think sort of the core in terms of determining, certainly the timing of the economist role, is the nature of the information that we're getting and at what stage. That's the biggest challenge for us, I think, across jurisdictions, and also the biggest determinant of the differences across jurisdictions.
Yes, Tamrat, do you want to add something? Peter just mentioned rules on disclosure, rules on expert or evidence production. What type of factors do you look for when you're in a legal regime for the economic assessment?
I completely echo Peter's thoughts. Disclosure is critical. Historically, the UK has been seen as more intensive in terms of economic analysis when compared with the European continent, because some places like Germany, for example, as Peter was mentioning, or the Netherlands have much more limited disclosure regimes. However, I mean, one thing I would say is there is maybe a little bit of a narrowing of the gap, and that's not because disclosure regimes are changing, but because of the nature of large opt-out consumer claims, effectively, in these cases, we often have to grapple with providing an analysis that is class-specific, but without any information for the class, right? It's not practical to gain information for potentially millions of consumers, or they won't have that long after the infringement. So that's a key tension we grapple with. Now, the UK and Netherlands regimes allow for aggregate damages, whereby that the fact that you don't have information for individuals need not be a blocker for the economists. So in that case, when we're trying to estimate aggregate damages, there's sort of two approaches, which are a bit more high level, which is maybe more similar to what you would see in Europe. So the first is, you might look at the total volumes of a particular good, or the average price of a good, sort of from public data or governmental data. You think of looking at pass-on at a sector level rather than at an individual company level, or looking at consumer spending as a whole as the volume of commerce, from a governmental database. And I think those aggregate analyses, they can be much more efficient and take less time, require less disclosure, but they do come with their drawbacks, right? One issue is Simpson's paradox, where an outcome manifests itself on the aggregate data but disappears when looking at subgroups. You might find, for example, an overcharge when you look at the average price of a product overall in an economy, but that could be when you look at, for example, the low-end products and the high-end products, you don't see any overcharge, because effectively what's happening is consumers are purchasing more high-end products during the infringement, which is then thereby driving up the average price. So there's a question of whether that's an effect, but effectively you have to be careful when using these aggregate data sets as well, because there's carve-outs from the class that need to be taken into account, and how do you deal with consumers that opt out, for example? If you have an aggregate data set, it may be difficult to remove the consumers that opt out. There's also, survey techniques you can use to survey some of the class. And I think these are two sort of higher level techniques that we're seeing employed more often in UK litigation, where you may not require, disclosure. So there's a little bit of a narrowing of the approach. But I mean, it's still in a lot of UK cases where you have sophisticated defendants with very large databases post-certification, there will be substantial disclosure and intensive analysis.
So just to add one thing to that, or maybe two things actually. So one is, I think it's going to be really interesting to see whether or not some of the aggregate damages analyses survive, because what we see in the US is very much the claimant's expert puts up a common methodology, and then the defense experts say, well, hold on, it's not common at all, and there's a group of class members who weren't affected, and so it's the common issues don't predominate. Now, we don't have a predominance test at class cert here, so that's sort of less directly an issue at the class cert stage, but once you get into measuring damages, it becomes an issue, and the natural response, I think, to quite a lot of questions on the claimant side, when the claimant's expert has proposed this aggregate damages analysis, is going to be to say, well, let's look at the real data, let's go to the individual level, and I suspect in quite a lot of cases we're being driven towards, we will end up being driven towards individual level analysis, even if the claimant's expert, its initial proposal is on the aggregate side. And of course, that raises all sorts of interesting questions around, what should be in the roadmap, what should be in the blueprint, the project plan. And as a claimant, if you're an expert on the claimant side of a case, do you, the extent to which you anticipate the defendant's arguments at the launch of the claim, and that could impact the disclosure you need. And so I think in some of these cases, it may be helpful to have, an expert discussion of topics like disclosure at the beginning. The one other remark I suppose it's worth making is, that the UK regime, I think, is evolving. And I'm the expert in the Boyle case, which involves the Gatwick Express. If anyone's come from the airport, you may have taken it. And the question in that case, the disclosure process, as I understand it, has moved away from what legal colleagues would describe as kind of standard disclosure, and is I'm currently ordered to provide a request for information, which is narrow and clear, and in the tribunal's words. And so the interesting question to think about then is what that means. So clear, obviously somewhat in the eye of the beholder, but but we have a good sense of that. Narrow, poses questions for the economists, which involve, is a narrow request a request for any documents that relate to customer evaluation of substitution possibilities? Is that a narrow request, or is a narrow request, documents which relate to substitution possibilities which are above some kind of materiality threshold? And if so, how do we, in terms of their relevance, and if so, how do we define that materiality threshold? And so, those are really pressing questions.
And interesting questions that arise in every jurisdiction. Thank you, Peter. We still have some minutes, and I wanted to leave at least a couple for questions, but I would just have a final question to Charles, if you want to add anything to this question of the impact of the different jurisdictions and legal regimes into the economic assessment. And also, you have mentioned that the challenges that you see across, Germany, other jurisdictions. And I was wondering if you have any thoughts on what would be the alternatives to the EU model of class actions.
I'm going to be contrarian. Today, it's Class Actions Symposium, and we're supposed to talk about representative and collective action. But I'm going to be contrarian, or you could call that out-of-the-box thinking. It's easy to think, oh, great class actions, that's an easy way of doing it, and for a funder making money, because then you can reach out to large volumes, not even having to find each and every client, at least in the opt-out. In the opt-in might be a bit different. But I have a legal and litigation background, but I had classes of finance, and I remember a professor of finance telling us, there is no such thing as a free lunch. I think people should remember this when you are dealing with group action, collective action, how you name it. There is no such thing as a free lunch. You talked about project funding. I think funding we're funding projects, litigation projects, but to me, collective actions are even closer to a true business project, because you have to deal with all sorts of things. Marketing, human resources, client relationship with suppliers, strategy, legal, finance, PR communication. So you need to put yourself in the shoes of an entire management team. And that's where, and maybe that comes from our experience, funding essentially opt-in group actions. And that's where we've been successful, because I think we learned to deal with each and every aspect of a collective action. Also knowing that one size does not fit all. And we should stop believing that there is a better way to do it. My colleagues always joke when I say Europe is a patchwork. But it is. And it will still be, in spite of the EU representative directive, it will still be a cultural and legal patchwork. You don't litigate in Germany like you litigate in Italy or in Portugal or in Sweden. So looking about, we are definitely interested in the alternatives. And there are, you have no idea. I may have sounded a bit pessimistic on the class action, but it's just because I think there are so many good opportunities to bring opt-in style group actions, whether you bundle the claims, whether you assign the claims, whether you appoint an agent based on principal-agent relationship, whether you have the test case. You just need to adapt yourself to the local environment. So there are lots of alternatives. A few tips: be careful when someone comes to you and say, oh, I have a smart idea. We've seen it in let's say, forum shopping. Yes, there may be some form of forum shopping coming, because depending on how you implemented the directive and maybe also how you deal with litigation funding, some people may say, let's go to that country because that's a country where funding is more easily available than the other country. That's true, provided that you have a real option between different jurisdictions. What we sometimes see is forum shopping because you want to avoid the natural forum at all costs, hoping you're going to gain time. The lesson is, I think so far, you can try it. It's highly likely you will find yourself in front of the European Court of Justice and lose another 2 or 3 years just dealing on jurisdictional issues. Mm-hmm. So my conclusion is, good to have the class action directive or collective action directive, but don't throw anything else. There are lots of great techniques of bringing claims before the court, even for groups that are out there in each and every jurisdiction, and it is certainly worth contemplating them. That's what we will keep doing as a funder.
Thank you. Well, we are already over time. I think we will be happy to answer questions, but probably over a coffee at the break. Thank you very much, and I hope to see you in Lisbon next year. And thank you.